Good afternoon, everyone. I'd like to welcome you all to the McGowan Theater located in the National Archives building in Washington, D.C. I'm Doug Swanson, Visitor Services Manager for the National Archives Museum and the producer for the Noontime Lecture Series. Before we begin today's program, I'd just like to mention two film programs that will be taking place at this location. On Friday, June 15th at noon, we'll be screening a new documentary film, The Hello Girls, which features archival film and photographs from the National Archives and tells the stories of America's first female soldiers. Then on Saturday, June 16th at 3 p.m., we'll be screening the world premiere of The Cold Blue, a tribute to World War II airmen and features gripping narration from some of the last surviving B-17 pilots, which are now in their 90s. This film is presented in collaboration with AFI Docs. To find out more about these, our other programs, and our exhibits, please visit our website at www.archives.gov/calendar. You'll also find some printed materials about upcoming events in the theater lobby. Our topic for today is the Lost Indictment of Robert E. Lee, the forgotten case against an American icon by John Reeves. John has been a teacher, editor, and writer for over 25 years. The Civil War in particular has been a passion since he first read Bruce Catton's The American Heritage Picture History of the Civil War as an elementary school student in the 1960s. Recently, John's articles on Robert E. Lee have been featured in the Washington Post and on the History News Network. Earlier in his career, he taught European and American history at various colleges in Chicago, the Bronx, and London. He graduated Phi Beta Kappa with a BA in economics from Syracuse University in 1984. Later, he received an MA in European history from the University of Massachusetts at Amherst and pursued a PhD in history at the University of Illinois in Chicago. He is currently working on a book about the Battle of the Wilderness. Please join me in welcoming John Reeves to the National Archives.
Thank you, and thanks for coming out, everyone, and just wanted to thank the National Archives, too. Today I'm actually going to be talking about a couple of documents and some discoveries related to those documents, so this is a sort of perfect venue for this particular talk. Let me just get my... Okay, there it is. There's the Lost Indictment that we'll be talking about in a second. I'd like to first start off by talking about the title of the book, The Lost Indictment of Robert E. Lee. So the title works on two levels. On the first level, there was a literal document, an indictment, that went missing for about 72 years and then was later discovered, but a lot of scholars don't know that it has been found. And I often never saw it cited and never saw the actual documents referred to. And in fact, I'll jump ahead a little bit. This is a part of the list of 36 Confederate leaders that was, 37 Confederate leaders that was indicted in Norfolk, Virginia in June 1865. And I had to compile that myself because there was nowhere where that had the complete list, but having seen the documents, I was able to kind of put it together that way. So this is a story about a missing document. But perhaps more importantly, the title refers to a symbolic indictment that had gone missing. That was the symbolic indictment was a legal and moral case that was made against Lee in 1865 and 1866 that was quite fierce and was in a lot of the northern newspapers and was conducted by luminaries like Frederick Douglass and others. And this is something that we've forgotten, the treason case against Lee and some of the rhetoric against Lee. One of the big themes in the book is that we have deliberately chosen to forget this history and instead have decided to remember the myth. There's a great example of exactly what I'm referring to. Just recently, the Southern Law Poverty Center announced a statistic that said only 8% of high school seniors can identify slavery as a central cause of the Civil War. So how have our kids not know that? And we can point to the teachers, but we can also point to the history that we remember, right? And I'm going to argue later, I'll go into more detail, that the lost cause interpretation of the Civil War became quite dominant throughout much of the 20th century, and that often, it wasn't slavery, it was state rights, or perhaps even tariffs, has become very pervasive in our society. One of the things I start off with in my book is, when I talk to people all the time about this, a lot of Americans don't even know that Lee and 36 other Confederate leaders were indicted for treason in a Virginia court in June 1865. And Jefferson Davis and was also indicted in Washington, D.C. just a week before then. So this sort of treason case is something that a lot of people don't know about. I think I'll just switch ahead for a second. There is the judge who presided over the indictments in that Norfolk, Virginia courthouse. His name is John C. Underwood, and he was a notorious abolitionist, originally from upstate New York, but he lived in Virginia and was a Virginia judge, and married to a cousin of Stonewall Jackson. So Underwood was this, sort of a fire and brimstone judge who brought the charges against him. And but yeah, I talk to people. Most people haven't even heard of this. Underwood was the most hated individual in Virginia in the 19th century. Ironically, Lee was the most beloved figure in the 19th century in Virginia. So you have the two poles right there. One thing that people often forget as well, in addition to not knowing about the treason cases, is that America was extremely divided in June of 1865. One of the things that we were often taught, and I know, and if you watch the Ken Burns Civil War, which by the way I love, we often get this sense that at Appomattox, we kind of buried the hatchet, so to speak, that Lee and Grant came together and they put bygones be let bygones be bygones, and that this was the moment that reconciliation began. But actually, 2 months later, in June, as we're talking about today, the United States government was pursuing treason cases against the Confederate leadership. So it wasn't quite reconciliation yet in 1865. And as a symbol of this, I have a picture here. Some of you probably are familiar with this picture. This is a photograph taken by Matthew Brady the day after Lee returned from Appomattox to a rented home in Richmond, Virginia. And so his wife, Mary, had rented a home in Richmond because, of course, their estate in Arlington had been seized. And so Lee returns home. This is the day after, and Matthew Brady is doing a series of photographs of Lee. And in this one, that is not widely known, I don't know if you can see it I've had the graffiti blown up, but in the red circle there is written the word devil. And that somebody had written that on the back porch of Lee's house, and then Brady snaps the photo, and then Brady, his eye maybe was good, but not as good as it should have been, realized, wait a second, this is no good, and he erased it, and then he took it again. And so that photo, the famous version of it, doesn't include the devil on there. But I just think that this is a great image that's sort of very symbolic, right? That look at, Lee, he looks like a gentleman, but he also is a Confederate general-in-chief at home. The war's over. But there's also this sign of some resentment and some anger. I don't know who put the graffiti there. Could have been a Union soldier. We don't know who did it. One thing I will say, too, this is a minor detail, not a big deal, but I found it interesting in the book, is that this photo was taken the day after Lincoln died. So if I gave you a brief chronology, Lincoln's assassinated on the 13th of April, on the 14th of April, excuse me, in April on a Friday. Lee returns home to his house in Richmond on a Saturday, and then Brady comes and takes the photographs on the Sunday. I speculate further in my book, and once again, we don't know this, and I won't go into too much details, but I speculate further that Lee may have just learned about the assassination of Lincoln right before the sitting. News traveled more slowly back then, but the individual who arranged to have Brady come to Lee's house knew that it had happened. So I'm just assuming, like I said, I'm speculating. I'm assuming that that's when he told Lee, but anyway, we think about, a lot of people say, there's a lot of news nowadays. Well, imagine that weekend, that it had been just a few days before you had Appomattox, and then Lincoln is assassinated, and then Lincoln dies. So there was a lot going on at the time. But anyway, I just wanted to mention that, so this legal treason case has been forgotten. The divisions of 1865 and 1866 have we've sort of forgotten. We kind of tend to think Appomattox marks the beginning of reconciliation. And I have one other illustration of this. Actually, before I do that, I'll go back to, I want to underline one point, and that is, we often don't think of Lee as facing such serious charges. But not only was he indicted, but they used medieval language in this indictment dating from the 14th century that was quite fierce, and I think it's worth mentioning. I wanted to at least read a section of it. But in the indictment, it accuses Lee of not having the fear of God before his eyes, nor weighing the duty of his set allegiance, but being moved and seduced by the instigation of the devil. So this is powerful stuff. And like I said, President Andrew Johnson, the new president, was in earnest about pursuing this case. So anyway, one thing I'd like to mention as an example of how we sort of overlook that period, that post 1865 and 1866, was, recently Chief of Staff John Kelly said in October, he said, it was loyalty to state first back then, and men and women of good faith just disagreed. And it's sort of this sort of hedgy, we all didn't, no one knew what was going on. That's not entirely true, as my book points out, and that is that the United States government always maintained that Lee and Davis were committing treason and had committed treason, and that Article 3 of the Constitution was where the crime of treason was defined, and it's the only crime that is defined in the Constitution. And that after the Civil War, the President of the United States, Andrew Johnson, the Chief Justice of the Supreme Court, Salmon Chase, the Attorney General of the United States, James Speed, and a federal judge in Virginia, John C. Underwood, all four of those men felt that treason had been committed and that the Confederate leaders needed to be punished. So I think we have to be careful of the both sides-ism when we think about the United States government's position on this. And I think that that's something that we're often forgetting. One thing that it's worth noting, too, Andrew Johnson was a Southerner from Tennessee, and James Speed was from Kentucky, and Underwood was from Virginia, but he was, to be honest, a Northerner. He was originally from New York State and had moved to Virginia as an adult and had been a tutor, and that's how he met his wife. But in any event, so that's one part of this sort of missing legal case that I think we have to consider. Some people might make the case that, well, okay, we did forget, but maybe it was a good thing to move on, and that reconciliation was more important than justice. This is a point that David Blight has made in his book, Race and Reunion, which I highly recommend if anyone hasn't read it. It's really good. But this idea that, maybe what really happened is that America just needed to move on and had to put all of this behind it and then therefore forgot that there was this still contentious debate going on after the war. It sounds sensible to put reconciliation above justice, but remember, too, there were 400,000 Union soldiers that died during the Civil War. That's a lot of widows and orphans that may have not wanted to put justice aside. But then we also have to remember the African-American soldiers who fought for the Union. And many of them were probably rightly wondering, well, I was fighting for the Union, and yet my civil rights and protections are not being firmly backed by the government, and that these Confederate leaders who fought to destroy the Union are being restored, pardoned, getting their civil rights back, their voting rights back, et cetera. I just want to share a slide. I think that this print from 1865 illustrates that. You can see on the left-hand side is Robert E. Lee bowing before, I think it's Columbia is the goddess or the image. Lee is bowing, and there's other Confederate leaders in the foreground. And it's symbolizing his receiving of a pardon or being forgiven for his actions. And in the right-hand panel is an African-American Union soldier who is disenfranchised and is wondering, well, what about me? So I think that's something we need to think about when we think about reconciliation versus justice. I'll jump ahead a little bit, and you, of course, already know that because what happened was that Lee wasn't prosecuted. He was charged with treason. The government was preparing cases first against Jefferson Davis and then the other Confederate leaders, and then they abandoned it. And that's what I mean by, the Confederate leadership was pardoned, and that there was this sense of moving on through the 1870s, 1880s, et cetera. One of the individuals who was most concerned about this move towards forgetting and this move towards putting reconciliation and healing above justice is Frederick Douglass. Frederick Douglass has made a comeback recently. We had forgotten about him, but he emerged last year. But he had gone around almost pleading with his fellow citizens to not forget what was going on. And at one point he said, we must never forget that victory to the rebellion meant death to the republic. So Douglass was quite aware that there was this move towards sort of forgiving and forgetting, and that's something that ultimately did happen. So there was this legal case against Lee. There was also what I describe in the book as a moral case against Lee. So, for example, after the war, Lee described himself as always being opposed to slavery. Right? That he said, in an interview he gave in 1865, he said, all the best men of the South were against slavery. And when he appeared before the Joint Committee on Reconstruction in 1866, he said, I've always been in favor of emancipation, gradual emancipation. A lot of union editors and political figures really called him out on that in 1865 and 1866 and said, you can't say that. You spent your whole life owning and managing slaves. On the eve of the Civil War, he was managing about roughly 200 slaves that had been left to him by his father-in-law. Lee was the executor of the estate. So he was responsible for managing these slaves that were, by his father-in-law, legally required to be freed within 5 years. And so Lee was responsible for managing the slaves for 5 years and then emancipating them as required by law. But nonetheless, Lee was someone who was involved with slavery, and his family benefited from slavery. So when he said he wasn't really interested in, that he is always opposed to it, you have to put that in historical context. But in the 1865 and 1806, regardless of what we think of his claims, there was a very active critique of his views, and they accused him of being a hypocrite and what have you. Some of you might be familiar with the Wesley Norris case, and Wesley Norris was a slave, one of Lee's slaves, who had run away, been caught, and then whipped and had his back washed with brine, along with his sister and a cousin. And he wrote up he gave testimony that was published in the newspapers in 1866 about this, which was very shocking to a lot of people, because it wasn't just that Lee punished his slaves, but it felt particularly brutal, the washing the backs with brine. Lee never defended himself publicly on those charges, but at the time when Norris and the two others ran away, Lee wrote to his son, and he said, "Your grandfather has left me an unpleasant legacy." So you could see that he was very frustrated with this job of having to oversee the slaves, and he may or may not have been a brutal master in the way he treated him. But this case of Wesley Norris is something I go into in a lot of detail in the book, because there's been, I think I counted, I did my best to count, but there were at least 7 or 8 different accounts of what happened. Some of them were wild. Like, one of them was, I'm not kidding you, one of the accounts was the master refused to whip Sally Norris, and then Lee said, "Step aside, I'll do it myself." That seems unlikely. But the most common version is the one put forward by Wesley Norris himself, who was there. And I think many historians believe that to be true. And my understanding is that that's the version that the National Park Service now accepts as being probably the most accurate account. So in any event, contemporaries were quite critical of Lee's claim that he had been always opposed to slavery. Another case that they made against Lee had to do with the treatment of Union prisoners. And there were charges in the press saying that, Lee was part of this leadership that mistreated Union prisoners, particularly in Andersonville prison. And some of you may be familiar with the Wirtz case, Commandant Wirtz, who the commandant of Andersonville prison, who was tried and executed. Lee was on the original indictment with Wirtz as a co-conspirator. And at the time, Secretary of War Edwin Stanton wasn't ready to prosecute leaders like Lee and Davis, because remember, these would have been war crimes in addition to treason, right? And Stanton said, "You need to rewrite this. We're not ready to go against them." A little, because it's the National Archives, I'll share this interesting what was happening at the time. Stanton actually had someone going through all of the Confederate documents at the time to find dirt on Davis and Lee. The smoking gun was that Andrew Johnson and his administration thought that Jefferson Davis was involved with the Lincoln assassination. And they thought that they would find a document that would prove that. So they were sifting through all of this at the time. And Stanton said, why did you put Davis and Lee on that indictment against Wirtz? We're not ready to move against those two. They felt that they already had sufficient evidence against Wirtz. So they rewrote the indictment and they pursued Wirtz separately. Of course, Wirtz made the cases like, I was just following orders. It's these guys who you should have been charging with the crimes. But it's sort of like the not to go too far afield, but it's sort of like when Goldman Sachs gets in trouble for some rogue trading, it's usually the junior trader that gets brought against, they usually bring charges against the, assistant managing director for the bond desk of Europe or something, and it's never the CEO or the CFO or whatever. But in any event, so there was this legal case, and then there was the moral case, this case against Lee as a slave owner and the case against him for prisoners. I argue that Lee probably doesn't deserve to be criticized for the treatment of Union prisoners on an operational level, because he wasn't involved in running things at Andersonville and Libby and some of these other places. But what I do argue is that Lee upheld the Confederate policy towards African American prisoners of war, which was to deny them with the basic protections under the laws of war. One of the things that the Confederates argued was like, well, this was our property. These were ours. Why would we treat them like normal prisoners of war? But in the book, I note that roughly one third of the Union African American Union soldiers had been free prior to the Civil War. So the South was essentially taking free men and often treating them brutally, sometimes re-enslaving them. And so to the extent that Lee upheld that policy, which was the Confederate policy towards African American Union prisoners, he bears some responsibility for that, I think. So that's part of this. This is part of the case against Lee in 1865 and 1866 that we've forgotten. Next, I'd like to talk a little bit about, okay, so what does that mean for today? One of the themes that I explore throughout the book is, how did a rebel chieftain who had been indicted for treason become a national hero? A hero first in the South, but later in the North. How did this possibly happen? And it's sort of one of those questions that's so fundamental that we often forget about it. This topic, of course, resonates with us today, I think, in light of first the horrific shooting in Charleston, South Carolina, and then the events in Charlottesville last summer. So this has really come back to us in many ways. Why did these Confederate leaders become heroes? I think we're having that debate now. But when I started thinking about this book, we really hadn't been having that debate. Since 2015, of course, we've seen the statue in New Orleans of Robert E. Lee come down. We've seen the window of Robert E. Lee at the National Cathedral here in D.C. has been removed. And I think 110 Confederate monuments and symbols have been removed since 2015. And there's actually 772 monuments remaining. So I think this is a moment where we're starting to think about this. And in the book, what I try to encourage us is to go back to the sources, go back to the 1860s and see what they were talking about then. Because in between then and now, a lot of myth has emerged. Okay, briefly, I want to get to the documents. So what I'll do now, though, is I think I just posed a question. How did Lee become a hero despite being indicted for treason? I'd like to briefly answer the question. I'll do my best to keep it brief, but this is how I answered in the book. In many ways, the book is a long unfolding of explaining this answer, but I'm going to give you the short version, the 60-second version, hopefully 60 seconds. And essentially it's this. There was this symbolic indictment that was made against Lee in 1865 and 1866. Not only was he indicted for treason, but he was accused as being a brutal slave owner and mistreated prisoners, et cetera, et cetera. Lee's response to that symbolic indictment his defense became what we now know as the lost cause interpretation of the Civil War. And what was that? It was that the war was about states' rights, not slavery, that the Southerners would have won if they only had as many men or they had as many resources. And then finally, what's the most critical component of the lost cause tradition? That Lee was a saintly figure and was this kind of divine figure who was the best soldier of the Civil War. And so that's what happened. That defense became the lost cause. And the lost cause, I'll take a step further, I think we could argue became, for much of the 20th century, the dominant interpretation of the Civil War, that's how many of us understood the war to be. I think it's changing. I think it's been changing relatively recently, but for a long time, and some of you may have been, I mentioned that statistic about high school seniors, like only 8% think slavery was central to the Civil War. But we see polls all the time, only 30% and 50% think it was states' rights or whatever. So, this lost cause interpretation is quite prevalent. Okay, now to the documents. Right here you'll see the Amnesty Oath of Lee, which is one of the most important documents in the collection here at the National Archives. I think, am I correct that it's held at the College Park location? I'm pretty sure. It's here. I've been told it's here, sorry. But there's Lee's Amnesty Oath, and I'm going to give you a little background on this oath. In June 1865, Robert E. Lee saw that Andrew Johnson had said that people could apply for pardons. Confederate leaders could apply for pardons. And so Lee actually reached out to Grant and said, hey, Grant, what do you think? Should I apply for a pardon? And Grant said, yeah, you should do it. So he sent in a pardon application. The pardon application was required that you also submit an amnesty oath. Lee did not submit the amnesty oath with his pardon application at the same time. This was, remember, June 1865. In October of 1865, Lee finally does sign the amnesty oath, have it notarized, and has it sent in to the State Department in D.C. And this is it right here. This is that amnesty oath that Lee took in October 1865. You can see his signature right there in the far corner, right. In 1970, and now we get into the world of sort of secret documents. In 1970, an archivist by the name of Elmer Orris Parker said that he had discovered this, that it had gone missing for over a century, and that he found it, and that now that we know that Lee had completed that pardon application process, shouldn't he be pardoned? Because if Johnson only knew that amnesty oath was available, that he had signed it, then Andrew Johnson would have certainly pardoned him. And it was brought before the Senate, and everyone in the Senate agreed, and the Senate unanimously felt that Lee deserved a pardon. It was brought before the House of Representatives, and they overwhelmingly voted in favor. There was one guy who felt that something fishy was going on, and his name is John Conyers, Representative Conyers, who's still with us today. And Conyers said, this doesn't seem right, that somehow this missing oath appears and now we've got to pardon Lee. He felt it was all sort of puffery and bicentennial nonsense. And Conyers actually sent an aide to the National Archives and said, tell me more about this document. And the people at the archive said, oh, we've always had this document. We've always known about it. It really didn't go missing. And then they told him where it went and whatever. So anyway, there was this. So Conyers was challenging his fellow congressmen, but they didn't want to listen, and they didn't really want to hear. And so it all went forward, and then President Gerald Ford, pardoned Lee at a ceremony at Arlington National Cemetery, which was once Lee's former home. And it was this kind of coming together. I would say most Americans in 1975 would have thought not only was that the right thing, but they would have not even realized that Lee hadn't been pardoned already. So this would have been, a kind of, there were probably very few Americans in 1975, although Conyers was probably one of them, who felt that Lee didn't deserve this honor. One of the funny things about history is that Lee didn't even need to be pardoned. That he had received a general amnesty from Andrew Johnson on Christmas Day in 1868 that applied to him. So a pardon was unnecessary. When Lee died, the only disability that applied to him was under the 14th Amendment, which meant that he couldn't hold public office under the 14th Amendment. But even that had been repealed in the 1890s. Some people said, yeah, but it didn't apply to Lee because he wasn't alive in the 1890s. But nonetheless, it really wasn't necessary to pardon Lee in the 1970s. It was much more of a symbolic gesture. But I thought that notion of the missing amnesty oath is interesting to point out. And then, as I mentioned in my book, it isn't the amnesty oath of Lee that went missing. It was the indictment that was lost, and that was lost for 72 years. And I'll mention this now. It was lost until 1937, and then a worker for the WPA was cleaning out an office in Richmond and stumbled across a box full of indictments from the Judge Underwood court. And that's how it was discovered after having gone missing for so long. And when I was hunting for these missing documents, I came across an article in the New York Times from 1937, and the headline was, "Indictment of R.E. Lee is found. Box yields long sought paper." And that's how I discovered that it had been found. So in any event, these are the two documents. This is the one, as I said, that had gone missing, and this is the one that had been at the archives the whole time. It gets a little confusing, but to give the details, but essentially it was the amnesty oaths were sent into the State Department originally, and they weren't transferred to the National Archives until the 20th century. And then, just as a funny historical detail, the application that Lee sent in to the State Department, Secretary of State Seward gave the that pardon application out as a souvenir to a friend, and it was later retrieved in like the late 19th century. But the amnesty oath, I think some people say it may have been misfiled or whatever, but nonetheless it reemerged and it was part of the National Archives collection in the 20th century. One slide I'd like to take a look at briefly that I haven't gotten to yet. This is the first mixed-race jury in Virginia history, and this was the Pettit jury that was in reserve, was ready to hear the trial against Jefferson Davis, and I thought that was interesting to mention because Underwood was not only an abolitionist, but he was a great champion of African Americans, and he made an effort to make sure that there were African Americans on that jury that would hear the case against Jefferson Davis, and presumably they would go after. They had decided to go after try Jefferson Davis first, and then presumably Lee would have been second. They would have tried him next. And one thing I will say about this too that I think is sort of interesting is the case against Davis, and then, of course, against all of the Confederates, broke down because the Attorney General, James Speed, I think, felt he was doing the right thing and believed that treason should be tried by a jury in a traditional court. And not only that, but treason needed to be tried in the location where it was committed, and in this case, Virginia. So if you think about it, if we stop and think for a second, how easy or difficult do you think it would have been to try Jefferson Davis and Robert E. Lee in a Richmond courtroom made up of ordinary Virginians after the Civil War? I think that the Union prosecutors looked at the odds of being successful in trying such a case and realized, all we need is one to think that treason hadn't been committed and that we would lose. So for his part, Underwood felt probably that having an African-American jury might improve the odds for a successful prosecution. But nonetheless, the government decided to drop the cases first, as I mentioned, that Johnson issued an amnesty for all of those Confederate leaders who had been indicted on Christmas Day, 1868. And then in February of 1869, the government prosecutors dropped the charges against all of the 39 Confederate leaders who had been indicted. So that's how, as one of the lawyers said, thereby closing out the rebellion, as he put it. So anyway, that's how. I just think that that's a interesting fact that came out of this case. I'm going to go back to the indictment. So, okay, I've just got a couple minutes before I'd like to turn it over to questions, but I'd just like to briefly mention how I got interested in this topic and how I was inspired to pursue this topic. And essentially, like many of you, I read about the Civil War. I'd been a teacher and I've been a historian and had been in this field for a long time. And essentially, I was reading a book about the April 1865, and it made the case that Lee was this great healer, this great unifying figure who tried to bring the North and South together after the war. And I thought that was interesting, and I wanted to read more about that. And as I read more about Lee, I realized, well, that wasn't quite true, that in fact, not only was he tried for treason after the war and not quite this unifying figure, but in fact, Lee himself was quite defiant after the Civil War. There's a famous interview, which I include in the book, by the way. I transcribed it myself. There's an interview in April 1865 where Lee is interviewed, and Lee says, if you guys go forward with treason trials and punishments, then the South might just continue fighting, and that this war might not be over after all. So there was a kind of a defiance in his tone, and that, yes, I think on one level, his decision to apply for a pardon, I actually make this point in my book, was actually a very noble act. And I think it encouraged a lot of other Southerners to also apply for pardons and try to put it all behind them. But on the issues of relating to civil rights for the freedmen and on some of these other issues, Lee was not actually that helpful and tended to be quite, opposed to trying to come up with a solution to the issues related to Reconstruction. So it's sort of a mixed bag, but that's how I got interested in this. And then I noticed that there wasn't really a whole lot written on the indictment or the treason cases. And Douglas Southall Freeman, who's the great Pulitzer Prize winning historian who wrote about Lee, said that the indictments had all disappeared. And that kind of gave me the motivation to try to find them. And then I went down the path of not only finding the documents, but then learning more about the case, and then realizing that the way Northerners viewed Lee in 1865 and 1866 was not the way we were viewing him in the late 20th century, early 21st century, and that something had changed and we had forgotten that. And then that was the kind of the kernel for the book. So anyway, on that note, I think I'd like to stop there so we can have some time for questions.
It's always been my impression that any kind of treason trial would have been mooted by the terms of the Appomattox surrender, that General Grant deliberately worded that document in such a way that it would guarantee General Lee would not be prosecuted for any kind of crimes. And therefore, this whole, was General Grant aware of this particular indictment? Did he have any reaction to it?
Oh, yes, great. Not only a great question, but I wrote a whole chapter about this question in the book. So Grant felt that the terms at Appomattox protected Lee and the Confederate soldiers from any prosecutions. You're exactly right. Guess what? Andrew Johnson disagreed. And so he sought out his legal counsel, and the key legal minds of the day felt, no, this is a military parole that was agreed to at Appomattox, and that once the war was officially over, then the government could pursue charges against this. Basically they felt that, two generals whipping something up together in the midst of battle wasn't a sort of a legal protection in perpetuity for these Confederate leaders. So it gets even more interesting. Grant, not being a lawyer but being a man of honor, said, well, I don't care what your lawyers say. I don't want you to go against these men. And he threatened to resign if Johnson did. And Johnson was like, yeah, well, you and I just don't see eye to eye on it. And so to close out the story, Johnson took two different strategies. One is, well, I'll concede that we have to wait until the war is over before we start going after the men from Appomattox. And that in 1865, the war wasn't officially over, and it wasn't legally over until August 1866. And then secondly, they all felt, well, why don't we just get started on Jefferson Davis? Because number one, Jefferson Davis wasn't protected by any paroles. And also, if we can't win against the arch traitor, how can we win against anybody else? But it's a very good point. One thing I do in the book as well, and by the way, I'm sort of a fan of Grant, but when Grant testified before an impeachment committee, he gave what I just said and said, me and Andrew Johnson, we just disagreed on this issue and we would always fight about it, and then we just kind of decided to go our separate ways. When he was older, the years unfold, and then Grant said, I looked him in the eye and I said, if you don't drop those charges, then the story got more elaborate and more bolder as years went by. So I include all of the different tales that were told. Interestingly or not, Andrew Johnson never gave an account himself of it, so we really only have Grant's. And I chose to emphasize the one that he gave, Grant's story that he gave under oath, rather than the ones that emerged in the later years. But great question.
Thank you.
Yes, yes, sir.
Thanks very much. A quick question and a longer question. Does the indictment, the actual document, now reside in the archives?
Oh, no. So it's now in the Library of Virginia. So to that point, though, when I came across that note in the New York Times that said, box yields alongside that paper, I called the National Archives, and they very, very helpfully said, your best bet is our Philadelphia office where we keep our court records. And so I went up to Philadelphia, and then they gave me the box, and I opened it, and in there was a yellow piece of paper that said, all of the Underwood indictments have been moved to the Library of Virginia in Richmond. So I went there, and they had them. And the reason why I think they're there is the Library of Virginia has a collection devoted to treason. So it has all the documents related to Aaron Burr's treason trial, for example, all of the ones related to Jefferson Davis, and then it has that box of the 37 Actually, you know, it's funny. I think there were only 34 in the box. 3 were missing. But with that list, I was able to cross-index by using newspaper accounts and stuff to get the other 3 that, you know, didn't have indictments in there.
How fully were the 37 indictments executed and pursued? For instance, John Breckinridge and Judah Benjamin fled the country,
Yep.
and some of the cabinet members were gone for a period of years. Were they fearful of the indictment? Did they know about the indictment, and did it keep them out of the country until it was officiated?
So they knew about the indictments for sure. And it's such a great point. Many of the ones who are under indictment did flee. One of them, who I write a lot in the book about, is a guy by the name of Jubal Early. And Early fled first to Mexico and then made it up to Canada. And Early was this cantankerous, unreconstructed Confederate. And he was a little more worried than the others because he had been responsible for burning the town of Chambersburg, Pennsylvania, and thought maybe they're going to come after me. So, but one of the things about he was such a pugnacious character. When he returned to America, you know, Johnson had issued the amnesty, and then they dropped the indictments, and then Early would go around saying they never had a case anyway, so of course they would drop it. So he was quite kind of, you know, we would probably use the word he's a bit of a troll, but he was always very pugnacious and combative. And then finally, many of you might know that Jubal Early's notorious for putting forward not the lost cause interpretation of the war, but also defending all of the various elements of it. And he was Lee's biggest advocate on the Battle of Gettysburg, for example, and defending Lee's actions and blaming everything on Longstreet. So Jubal Early's a fascinating character. Yes?
Hi. I think you make a great point about being indicted for treason, and then what happens if you're acquitted. What does it say about the entire war, that if someone's acquitted? And I think that's a point you were driving toward. But what about the amnesty application or submission of that amnesty application? Was there sort of an acknowledgement in that application of being a traitor?
Great point. So, and I think this has been in the news a lot lately, isn't it? Attorney General James Speed, I kind of researched this a little bit. Attorney General James Speed felt that by accepting the pardon, it's an admission of guilt. I've been reading now that some legal scholars feel that that's still up for interpretation. So that was the Attorney General at that time believed that to be true, but obviously the law is in flux and there's people who have different opinions, but that's a great point. One thing I'll also say, you know, I devote a lot of time to the pardons because it was a big thing. In fact, not only were there so many pardon applications, but there were so many Confederates doing, you know, taking oaths and sending applications in that Johnson was spending all of his time doing this. And one of his colleagues said, you know, the presidency was not created for this. Like, you're sitting around signing pardons all day. And then one final point that I have to say I grudgingly admired Lee for this, and that is many of those who submitted pardon applications sent in tons of documents, you know. Here's my 8th grade teacher. He says I'm a really good guy. And here's my wife. She likes me. And, you know, it's stacks of stuff. Lee's application literally was, you know, I'm Robert E. Lee. I was General of the Confederate States of America. I went to West Point. I live in Virginia. R.E. Lee. You know what I mean? It's like, it was literally like less than a paragraph. I don't know. It took a little bit of, you know, it took a little bit of defiance, maybe is the word, to not really put much effort into his pardon application. Yes, sir.
Yeah. If my memory of history serves, and you may have covered this in the few minutes before I got here, an attorney from Kentucky, Bledsoe, I think, wrote a book that was really a brief that basically argued that if they tried them for treason and they lost, and they've got an acquittal, that the Confederacy would have won by judicial interpretation what they lost in war. And could you address that? That seems to me there was an enormous effort to lobby the cabinet to not prosecute because of the fear that the judicial interpretation could ratify the Confederacy.
Yeah, excellent question, because I actually include, so I'm not familiar with the brief that you're referring to, but I include in my book a memorandum by one of the prosecutors in the Jefferson Davis case named Richard Dana, who wrote it out why he felt that it was smart to drop the case in 1868, and he makes many of those points. And you know, it's such a beautifully written document that I put it in the appendix because it's an impressive legal argument. And basically, he's saying, look, we've already got what we want. We won the war. As a result of I don't want to get too in the weeds, but there was a judicial ruling during the war called the prize cases, where the government's position that this was both a war and a rebellion was upheld, which meant that the government could pursue traitors and bring charges against them. So Dana was, by the way, the lawyer on that case. So Dana said, look, we've got what we want. We won the war. We've defined secession as treason. And that to go forward and put all of this in the hands of one guy in a Virginia jury who could therefore nullify everything by coming back with a not guilty verdict, that we shouldn't do that, and that was too much of a risk to run. And so that was persuasive, and that was basically the reason why. That having been said, Andrew Johnson was a little bit on the fence. And eventually what was another factor in dropping the case is that Chief Justice Salmon Chase, who thought that treason had been committed, didn't really want punishments and executions and all this sort of thing. So he was open to the principle that under the 14th Amendment, which punished Confederate leaders and thereby wouldn't let them serve as in political office, that to try them and punish them again would be double jeopardy. So Salmon Chase was literally leaning towards dropping it anyway. And when the prosecution said, oh gosh, one of the two judges is not on board with this, they said, you know what? Let's fold our cards and just end this thing. And then that's what they did. But the Dana argument was so good that I thought it was worth adding to the book. Yes?
I had a question. Obviously, you've studied this very intensely, and I was wondering, do you have a sense, was Lee sorry that he did, that he was...
Yeah. I'm going to answer no. And that I think Lee's take was that he wouldn't have done anything differently. Okay. Now, maybe there's some psychoanalysts in the room that would say, well, that's a defense. I'm not a psychoanalyst, so I'll take him at his word. But he made the point, it's like, I wouldn't have done things differently. And one of the things that I found fascinating about Lee is, you may have been familiar with this, is that in 1861, he was quite ambivalent about secession and whether or not secession was a good thing or even legal. But after the war, he started reading up on constitutional theory, and by the end of his life, he was committed that secession was legal under the Constitution as it was understood in 1861, and so he had done nothing wrong. Okay. So yeah.
Okay, thank you.
Yeah. Okay, I've been told that's it for questions. Well, thank you very much for having me.
Folks, just a reminder.